The Pietermaritzburg High Court has adjourned to the 16th of February the application by former President Jacob Zuma for leave to appeal Judge Piet Koen's dismissal of Zuma's special plea that State Prosecutor Advocate Billy Downer has no title to prosecute his corruption case. Judgment is expected to be handed down on the 16th. Earlier today, the court heard that it would not be in the interests of justice for former President Jacob Zuma to wait until the end of his corruption trial to raise an objection that could impact on whether he received a fair trial. Zuma is applying for leave to appeal the court's refusal to grant his application for State Prosecutor Advocate Billy Downer to recuse himself. The defense is arguing that Downer is guilty of misconduct and is biased against Zuma. All right, now to help us make sense of today's court proceedings, we're joined via Zoom by legal expert Mr. William Booth. A very good afternoon to you. Thank you very much for joining us here on SABC News, sir.
Good afternoon.
All right, let's start with some of the arguments that were presented on behalf of the former president by Advocate Dalimpofu. He spoke about the issue of interpretation and whether or not there is a reasonable possibility or prospect that another court, perhaps a higher court, could find a different or wider interpretation of Section 106(1)H, especially in relation to Title to prosecute. Let's talk about this. What does he actually mean by this? Is there indeed a possibility that another court could indeed find differently on this issue?
Well, that's what the test is about. So with any application for leave to appeal, the basis must be whether another court may come to another decision, or is there a reasonable prospect that the decision made by Judge Koen is incorrect, that another court would in fact find to the contrary. So, the application is in front of the same judge and has to be a factual one based on what was submitted previously. I think in Judge Koen's ruling, it was very clear that, previously that there was in fact no basis to have Downer removed, that the special plea that was submitted to the court, in fact, had no basis on the facts and in law. It's quite a unique application to raise a special plea and then to argue that the prosecutor doesn't have title. In other words, that he is biased, has prejudged the area, the whole case. Yeah. And is not going to apply himself objectively when prosecuting the matter.
Speaking of applying oneself, sorry, Mr. Booth, speaking of applying oneself objectively, I've always found this quite strange, given the fact that we're saying that, we need to see if there is a reasonable prospect that another court could come to a different conclusion, but we're asking the very same Judge Koen, if he himself thinks that, I could actually be wrong, and in fact, another court could indeed find that I had erred. And so this is always quite strange to me, and could the Judge Koen then be able to apply himself in that way to say, yes, I could actually be wrong, and in fact, there is a reasonable prospect that another court, a higher court, could in fact have a different conclusion, in which case he would then have to grant that leave to appeal. How does all of this actually then play out, especially in relation to this particular case that we're talking about?
Well, yes, I think, the public out there might ask that very self-same question. How can the same judge, as it were, find that he may have been wrong and that another court may have come to another decision? But again, every judge is legally trained. He has to remove himself. He has to remove the emotions from his decision and re-look at it. And if there is sufficient argument submitted during the application, he may well, and in fact, it has happened in previous decisions. I mean, Zuma had this granted in the North Gauteng High Court, where the judge found that another judge may come to another decision. So judges are trained to kind of remove themselves from the hurly-burly of the matter and to say, well, even though I might have said, something, that it might be that another court come to another decision. Obviously, if he finds, and you see, because it's a unique application, and I believe he applied his mind correctly at the time. I believe there is no basis But again, he might say, well, let's give, if there's any doubt, let's give the benefit of the doubt to Zuma, and let's see what another court makes of it. If he finds against Zuma, then they can petition for leave to appeal. They could petition the Supreme Court of Appeal for leave to appeal. So the other argument, I think, which is being submitted on behalf of the state is this a matter that should be dealt with on appeal, or should Zuma wait until the proceedings are concluded, and depending on whatever decision is made, that he could then raise that at that time, and that it's purely an interim situation and the courts shouldn't deal with it now on appeal, but let the case continue. And if, let's say, he is convicted later and sentenced, that that he always has the right to raise that at a later time.
Yeah.
I think his argument is, well, that would be unfair because you must decide now. So even if the court decides in favor of Zuma in this matter, that he has successfully argued the special plea, the point is the prosecutors can, or the NPA, the prosecuting authorities, can always appoint another prosecutor to deal with the matter.
Right. I want to go there. Yeah, I want to go there, Mr. Booth, and that's actually quite an important topic, because I know it was raised by Advocate Dalimpofu. He said, are there no other prosecutors in the country? But there's something else I want to talk about, and I was paying attention to what he was saying, and I don't know if this was a slip of the tongue, but he said something like this is not only based on bias of the prosecutor, but misconduct, and in fact criminal misconduct, and he referred to the prosecutorial code. And if he's saying that there's some kind of criminal misconduct, then surely this can be dealt with in another way, in a criminal procedure sort of way. Or could that have been a slip of the tongue? Because I really wanted to understand what he meant when he said this could actually be a criminal misconduct on the part of Advocate Billy Downer.
Well, look, obviously you can have misconduct as a prosecutor, which doesn't necessarily amount to criminal conduct, but can be dealt with by the NPA itself, and who would set up an inquiry to deal with the competency of a particular prosecutor. And the prosecutor could then be potentially, let's say, fired if he has contravened the code. So that's another inquiry to be dealt with at another forum. Yeah. If there's enough evidence to say a particular prosecutor has committed a crime, well then, criminal charges could be laid, and then that prosecutor could be criminally charged. I mean, let's say a prosecutor who goes and clearly commits theft or commits robbery or whatever, then he could be criminally charged for that kind of offence, and that's dealt with in the criminal courts. So if there is evidence of that, that is dealt with separately. The point still remains that even if Zuma is granted his application to have Downer removed from this case, that is going to help him in the sense it's not going to set the whole case aside. So that is why I'm saying that it is a point that the court might decide should not be dealt with by way of an appeal, that it should be dealt with later at some time if it's argued that he doesn't receive a fair trial. And that will be determined later, potentially at the end of all the evidence. Then it can be raised, because you might have a case where you raise a particular legal point early on, that if you succeed, that you can then be acquitted completely of the charge. So let's say and Zuma's tried this point, unreasonable delay. So if a court finds that your case is being unreasonably delayed, it could, in fact, acquit you. You could get a decision of a permanent stay of prosecution. So that could amount to, the state not being able to continue with the case against you. But that's not the situation here. Okay. So even if Downer is removed from the matter, there are other prosecutors who would be able to step into his shoes, those that have been assisting him, unless on the next stage that Zuma says, well, hang on, they're also just as biased, and they should also be removed from the matter. But that's not his application at the point.
So I took a long way, actually, Mr. Booth, to get to the main question. And of course, you've now actually then touched on it. I think you anticipated where I was going with this. A lot of people are, saying that the former President Jacob Zuma is playing all of these delay tactics. And one can argue, listen, if you've got the money for it, you've got the finance for it, you will really put the law through its paces, as one would when you're able to do so. So why doesn't the NPA then say, listen, there's a problem then, it seems, and it's causing a delay. And I think this is what Advocate Dalimpofu did argue, is that there's a problem with this advocate, Billy Downer, and it's making us delay this whole process. Let's then put someone else in there, in his place, that can carry on with the case. Or why is Billy Downer himself not saying, let me recuse myself for the interests of justice? The country wants to see where this case is going to go. Why is this happening? Why is the NPA not actually interjecting at this point? I actually heard a legal analyst speaking to my colleague just outside the Pietermaritzburg High Court saying, I don't know if this is an issue of ego or what is going on here, but really, let's talk about it. Why would there be such an issue with removing Advocate Dana, or he himself just choosing to recuse himself?
Well, look, obviously he could consider that, and I suppose one could sort of phrase it in the right way to say he is doing this. He's not admitting that he's done anything wrong. He's acted properly throughout. He's not conceding to any of Zuma's allegations, but he feels to get the case moving that he would step down and let others that have been working with the case take over. So, yes, that is an argument that should be looked at. But I think at the end of the day, the NPA must make comment why they're not taking that line. So he doesn't have to say, well, I've done something wrong. He can say, I've done nothing wrong. But, because Zuma's taking all these points, I want the case to go on. Even though he does that, the fact still remains that Zuma could take another point. And so we go on another issue, and then you have even more delay. Because if you look at the history of all ex-President Zuma's cases, I think the only inference any reasonable person, you don't have to be a lawyer, can draw is there is delay from his side. I mean, that's with respect to him and his legal team, that is my view. But the point you raise, I think, is something that the NPA should consider and maybe make a comment or raise it in court. And I'm not sure if it was raised at all today by anybody from the state's legal team. I'm not sure. I didn't listen to everything, obviously. Yeah. But I think that is something that needs to be looked at in the interest of getting the case moving. But they might say, well, he might raise all kinds of points as we go along. So it doesn't really make any difference. Get a decision on the point. So hopefully there'll be a decision soon in February. But then again, if Zuma application is turned down, as I said earlier, he could then petition. And then that's a further episode in his saga to try and prevent this trial from starting.
All right. Mr. William Booth, it was a pleasure speaking to you. Thank you so much for offering us your legal expertise on the show. We'll certainly be catching up with you, hopefully, at a later stage. Thank you, sir.
Thank you.
All right.